You realize it's 10, right?
Yes.
Okay.
Yes, and I'm looking. I don't know oh, there we are. Okay, it's 10. I'm gonna go ahead and get started. Most of you know who I am. I am Sarah with Celebrity Title. Thank you guys for coming and joining this morning. Um, we are here with Mr. Bond and Mr. Brown with Bond Law Firm, and they are going to be discussing listing homes for disabled or deceased clients. So if you have any questions, you can use the chat box in the bottom, and they'll be more than happy to answer questions for you that way. Also, if you need to email them, I think there was a link in their email that will allow you to ask further questions. Also, at the end of this, you will be able to, if you want CE credit, you'll be able to do that at that time. And I'm going to turn it over to Mr. Bond and Mr. Brown and let them go ahead and get started.
Sarah, I want to thank you for hosting this today, and we've considered a real opportunity to have a chance to speak with your folks here, and we hope it'll be real helpful to
Supply chain capacity and projection of shortage.
Okay, hold on just a second. I'm gonna have everybody mute their video and just let Mr. Bond and Mr. Brown talk.
Perfect. All right. Thank you, Sarah.
Yeah. So I just want to thank you, Sarah, for hosting this. It's a real pleasure and for us to be able to talk with your folks here about a subject that we're deeply involved in. And I think all of the people who deal in real estate are involved in this. You all end up listing homes for people who you're working with somebody who's got a family member that's disabled or who has passed away. And so this is a very frequent situation when in your business. And obviously in our business, since we're estate planning attorneys, we do this all the time. Now you might think that it would be better to talk to a real estate attorney about a lot of these things because you work with real estate attorneys at the title companies and so forth. But the joke is that it's estate planning attorneys that do all the deeds, and that's why they need real estate attorneys to straighten them out. But at any rate, we get involved with a lot of real estate transactions just like you do. So we hope that this will be real helpful to you. And as we get started, let me introduce myself. So I'm an attorney and CPA. I've been practicing, the law firm's been in operation for 26 years now. And we've been in the Greens Point area. And I'm a native Texan. I grew up in Dallas, went to Southern Methodist University. And then when I finished my last exam at Southern Methodist University in 1968, I went home and I got a draft notice. So as it turned out, my occupational choice was set for me for the next few years. And then as it turned out, I never got out of the Army. So I was in for 20 years and I retired in 1989 as a Lieutenant Colonel Infantry, regular Army. But I'd always said at some point, I think I'm going to go back to law school. So the next month, I moved my family to San Antonio, and we went to St. Mary's Law School in San Antonio for 3 years. And then in '92, I ended up in Houston because I took a job with Arthur Anderson, the once famous accounting firm. Of course, they got mixed up in the Enron scandal a few years later, but when I was working for them, they were going strong. It was the largest accounting firm in the United States. They hired a few attorney CPAs for their tax department, so that's what brought me and my family to Houston. After a couple of years, I started the law firm. Now, when you start a law firm, you know, you can defend criminals, but I never liked being around criminals, and most of them are guilty, so I didn't really think that suited me too well. Another opportunity would be to go into family law, which sounds kind of nice, except as you all may know, family law is really about divorces. And people who are divorcing are unhappy and they want their attorney to be unhappy with them. And I just didn't fit with my personality. So I decided that I would focus on estate planning and probate with the idea that this was an area where I could help people protect their families. And so, of course, when I started this, I wanted to have a good business, but as time's gone by, I've taken it as my calling. And it's never been a one-man show. I'm blessed that I've had Stephanie Searcy's worked with me since 1996. Kathy's worked with me since 2000. Mary's worked with me since, I don't know, 7 or 8 years. Our Medicaid experts worked with me for, I don't know, 8 or 9. Chris is kind of the new guy, and he's my partner. And he is a great person. And one of the reasons he's here is to carry the law firm on into the future. And so the law firm, we have thousands of clients here in the Houston area. We feel a real responsibility for them. And as time goes by, people need to come back and update their wills and trusts. They need advice. And then when people pass away or become disabled, they need assistance from the law firm. So we are like you in that we want to foster great relationships with our clients. And when we work with you, we want to reinforce your relationship with clients if you refer someone to us. Now, one other aspect of this is that it's really all about families. And the point of continuity in my life has been my sweet wife. We've been married 51 years, and we have a son and a daughter and 7 grandchildren. So we're truly blessed. With that, let Chris introduce himself.
Thank you, Bob. All right, so I'm going to turn in with the firm, as Bob said, a new partner with the firm, and I'm extremely excited about that because I think it's just worthwhile what we do for a profession here. It's more than a profession. It's really something that we're passionate about. And so I've been a licensed attorney since 2017. So there's my picture there. First thing I notice every time I see it recently is, gosh, I need a haircut. So I'm looking forward to that. But so before working with the bond law firm, I was managing assets for a large family estate. And, that was fantastic and all, but the opportunity that I have now to work with families on a daily basis is really worthwhile to me and means a lot. Before that, I got my law degree from the University of Houston Law Center in 2015. And unlike a lot of law school students, I had a couple of years in the real world after college. And so I worked at Lockheed Martin Aeronautics up in Fort Worth. I worked on the F-16 program. Great experience, amazing machines that we were building. And the reason I ended up at Lockheed was in 2009, I graduated from Texas Christian University with a double major in finance and supply chain management. Well, I was passionate about finance, but 2009 was a terrible time to be graduating with a finance degree. So that's how I ended up in a supply chain role. And then even more importantly than any of that is that when I was a high school student here in Houston at Cypress Springs High School, I met a beautiful young lady, and she agreed to go out with me, and I never let her go after that. So my wife and I started dating when we were sophomores in high school, been together ever since, and we just celebrated our 10-year anniversary. And we have a boy who turns 9 this year. And so family is extremely important to me. I know it's extremely important to Bob, and that really shines through in our working with clients because we understand how important it is to our clients. All right, so we appreciate you joining us today, and some of the topics that we're going to go over are, first of all, we're going to discuss what is estate planning and why does it affect you individually and as a real estate agent. We're going to talk about selling the home of a person who is incapacitated. Then we'll discuss selling the home of a person who's passed away. Then lastly, we're going to go over a simple solution to a lot of the issues that we're going to talk about throughout the presentation. All right, so what is estate planning and why does it affect you? Well, when you think of estate planning, you can think of a million different things. I know I could talk all day on anything having to do with estate planning, but there's really only one thing you need to know at the moment. It's that it's important. It's extremely important. If you Google the importance of estate planning, you'll just get bombarded with articles talking about why you need to have something in place. And this is true for your clients also. And so when most people think of estate planning, they think of, first of all, death. So they're thinking typically a will, and that's it. Well, estate planning is so much more than just what happens after you pass. It's also planning for incapacity, so it's disability planning. It's also planning for long-term care, because more and more Americans are ending up having to have long-term care, nursing home care in their later stages of life, and it's expensive. It's downright expensive, and that can destroy an estate. An entire nest egg that was saved up over a lifetime can be spent pretty easily in a couple of years. And so it's also about how your assets will be handled when you can't do it yourself. So that's really what it is. Now, we like to deal with not just the assets, but the family and the personal circumstances as well. But really what it boils down to is, how will your family actually become the owner of your assets once you're gone? So you think of your house, bank accounts, any investment accounts you may have, cars and personal property. All of these things are types of assets, and they don't all exactly work the same when something happens to you. And so you want to be able to have a plan where all of these assets flow in a controlled manner. And then, of course, most importantly, why is this important to you? How does it affect you as a real estate agent? Well, I'll tell you right off the bat. One reason it affects you as a real estate agent is that you're going to see these circumstances come up that we're talking about. And having a basic understanding of the estate planning elements and concepts that you'll be presented is going to be important. It's going to make you look good to your clients, make you look competent. And it's also important to have a relationship with an estate planning attorney that you feel comfortable calling upon whenever you have any questions concerning any of these issues. And so off the bat, and this is especially true for our practice as well, is you have to determine the nature of the relationship. So who is actually your client? Because it's not always the owner of the house who contacts you. It could be the daughter, the son. There's numerous people it could be who don't actually have authority to sell the house. And so just like us, we've got to define the nature of the relationship at the onset. And you'll notice at the bottom of this slide, there's a practice tip. Keep an eye on those. Those are real helpful, we believe, in your practice as a real estate agent, for things to look out for, things to know. And so when somebody is disabled or has passed away and they're a homeowner, then the person who you're likely approached by is going to be one of their children or their surviving spouse. But a lot of times the person you're contacted by is just the loudest person in the family. And that's not always good for you. You want to make sure that the person that you're dealing with is the one who's going to have legal authority to sell that home and sign those closing documents when you put all your hard effort in to getting the home to that stage of closing. And so, like I said about the loudest person being the one who contacts you, there's definitely going to be differences between siblings, and we see it all the time. And so we threw this joke in. It says, "And I'm sure I can trust you not to fight over my money when I'm gone." And they say, of course, holding weapons behind their backs. A lot of times, unfortunately, we're always trying to bring families together when somebody passes away or becomes disabled. And that's something that good planning can help with. However, there's still lots of instances out there where siblings don't get along, and it only really shows its head after the person has passed away. And so you really do need to be careful. All right, so the bottom line about what estate planning is and how it affects you is that this is also very true for our business, is that assumptions are trouble. You have to ask questions. You can think of your questions sort of like a paintbrush. Choose it carefully, treat it well, ask your questions specifically. And the reason why is you want to paint a full picture. And by painting a full picture, you will avoid having sudden delays pop up right when you're ready to close, because time is money. Now, additionally, clients are going to appreciate that you have competency in these issues. They will always appreciate that when you know more than just how to sell a house. And additionally, they're going to appreciate that you have network connections with professionals who are able to help them in these sort of situations. And then lastly, it's important because don't forget about yourself. You know, we're going to focus this presentation on how estate planning really can affect you as a real estate agent. But as we're going through, think about your own personal circumstances as well, because you may realize that either you're not protected at all, or you may have thought you were protected, but really your plan isn't as thorough as it needs to be. And so we'll go through a variety of instances where that may be true. Okay, so we move on to part 2. You know, the daughter or the son that's approached you to sell the home. Well, that's not how the law defines incapacity. And really the good news for you is you don't need to worry too much about how the law defines incapacity. You just need to know if there is a question of incapacity. So you need to ask, you know, does mom have capacity to sign the closing documents? If not, well, then who has legal authority to do it? Because incapacity does not by itself give somebody else the right to act for that individual. There needs to be something providing authority. And so really where the rubber meets the road is once you get to sell, it's time to sell the home of a person who's incapacitated. Let's talk about how that's going to work. And so, like I said, just in the previously, if daughter comes to you and says they need to sell mom's home because she can't manage it anymore, she's not in good health, first thing you need to ask is she going to be able to sign the documents? Does she have competency to sign the documents when it comes time to close on the home? If so, that's good. But if there's any question about whether there's incapacity, then the next thing you need to ask for is whether or not mom has a statutory durable power of attorney. And if so, is the person who approached you the first listed agent? Do they have the original in their possession? And it does need to be the original. And there's lots of different power of attorneys out there. You'll notice on the practice tip down here that a statutory durable power of attorney is different than a healthcare power of attorney. I mean, completely different. They handle completely different sets of issues. And so you need to make sure that you're looking for a statutory durable power of attorney. Some of the things you want to look for when you get the power of attorney, if they have one, first of all, is it just one family member? Is it the person who contacted you? Additionally, are there other listed agents that are currently serving along with the person who contacted you? And you might have to look to see if they have to serve together or in a particular order. And most importantly, you need to see if they all agree, because there's a chance, even if they can act independently, the title company might request that they get the approval from all listed agents at that point in time. And so it's important to know of not just who's listed on the document, but also the personal circumstances. You know, what are the relationships like in the family? And are there any reasons to be concerned about the closing going through? All right, so this is what you want to see, and you'll be able to get these materials on the email that was emailed out. This is an example of a good statutory durable power of attorney. And so let's look at just the document itself right now. So looking at the title, statutory durable power of attorney. Well, we know power of attorney, that's somebody being able to act for another. But statutory, that's there because the power of this document is derived from a statute. And it's durable because the power of attorney survives the principal's incapacity. And so if it's not a durable power of attorney, then it's only if the power of attorney is only effective while the person is alive and has capacity. So it has to be a durable power of attorney to survive beyond their incapacity. So you may run into, there's again, lots of different powers of attorney out there, and you want to make sure you're working with a statutory durable power of attorney. And then what you want to look for is look to see, does the power of attorney specifically mention the authority to transact real estate? I mean, that's what we're wanting to do here, right? We want to sell some homes. But even then, be careful. There are specific laws in Texas on how it must read and how the estate must be transferred. And so sometimes we see these power of attorneys that come through our office, and we see a wide variety of power of attorneys, and from great to terrible. And so some of them say, my agent is to have every power that I have. Well, that sounds great, right? I mean, that's just all encompassing. Wrong. That's not what you want to see, because the financial institutions, the title attorneys, they're going to want to see something far more specific than my agent can do anything that I could do.
This is completely useless.
Yeah, there you go. Completely useless. When people think that's great, it's not at all. So this is more like what you want to see, a list of the powers that the agent has. And so you'll see the first one here is real property transactions. Well, there you go. But still, that's not very specific, right? So if you look down at the bottom, it says these powers are more fully described in the Texas Estates Code. A copy of these provisions is attached to this durable power of attorney. Okay, so there's more. Number one here, referencing real property transactions, is just sending you to these articles and these sections, which has far more specificity. And so this is what it shows in the actual Estates Code. And this is just a little screenshot. The description of what it means to transact real property transactions with the power of attorney document is about 2.5, 3 pages long. And so this is what the title attorneys and the financial institutions are looking for, because it clearly spells out what powers the agent has to act. Now, powers of attorney will be accepted by title companies, but they are treated with caution. What is it that you always say about a power of attorney?
It's a license to steal.
A license to steal. Yep. So that's why they're treated cautiously, because there is a lot of fraud that happens with these documents. And so first of all, the title company is not going to accept it if it's not properly notarized. Additionally, it has to be the original. This is very important. A lot of times people bring in copies and just have a hard time finding that original. Well, it is really important that they find the property. We just talked about that. And the principal, the person who creates the power of attorney document, has to be alive, and you may actually have to prove that they are alive. And so a power of attorney document is a disability document. As soon as the principal passes away, it has no more effectiveness. It ceases to be effective at that point in time. So you can't sell the home of a deceased person using their power of attorney document. It just won't work. Now, all of these are things that you're going to want to know early on in the process when you're dealing with the family member who's approached you to sell the home. You're going to want to see this power of attorney right off the bat, because you're going to want to ask them these same questions. Hey, can you get me the original? Was it notarized? You might want to look at the document. And so you want to get this done quickly, because the last thing you want to do is be held up at the time of closing because the power of attorney is just worthless. Okay, so when you do get the power of attorney, so you ask the daughter or the son to see the power of attorney document, give it a quick review. There's a couple of things that you can look for on your own, and that'll give you at least some idea on the quality of the document and how effective it may be. So first you want to look at the signature. Is it legible? And it doesn't have to be, a perfect signature where you can read exactly what their name is letter for letter. I don't think any of our signatures are that legible. But the title company is going to know what they're looking for. And it's going to be something real shaky, you know, more just a mark. And you can tell when somebody, it looks like their hand was guided or they had extreme difficulty making that signature. What it's going to do is cause the title company to start asking questions and really want some verification that the homeowner does have capacity or that they did at that point in time when they signed the power of attorney document. Additionally, does it list the powers that are needed to sell the home? And we talked about that. When was it executed? So power of attorneys documents that are much older are going to be treated with more skepticism because the title agent or title attorney doesn't know whether another power of attorney document has been created since then. So if it's a power of attorney that's 20 years old, well, there might be some additional questions and holdups having to do with that. And then lastly, are there any conflicts of interest? So is the agent doing something for their own personal benefit? Now, that won't disqualify using the power of attorney document, but again, it will raise more eyebrows and more questions will be asked. And then lastly, you know, so you can go through this document and you might see some obvious faults, but what you should do is if you have questions, give us a call. We're here to help. And, you know, we look at these documents on a daily basis. And so we'll be able to take a look and see if there's anything that jumps out as being an issue. And if there is an issue, you know, how can we start addressing that now as opposed to right when you get time to close? All right, Bob, would you mind running us through a quick case study real quick?
Well, sure. So you meet with this lady and she wants to use her mother's power of attorney at the closing. And then, and as the conversation goes on, she also mentions that her mother passed away last week. Is there a problem? Well, yes, like Chris said a minute ago, the power of attorney is void once someone passes away. And so this is not going to fly as it stands. And the only thing is, the reason for mentioning it again for you is that a lot of times when you see clients, they think that you're just wrong. That, oh, sure, we can still use it. Why would it not be any good now? Yeah, mom just died. Why can't I use it? Well, they can't use it. So perish the thought. If this is still a problem of clarification, that's a golden opportunity to give the law office a call and we'll help your client to understand that that's not going to fly. So that's a problem. How about this? Your prospect shows you a power of attorney that she is planning to use to sell mom's home and asks your advice. And so then what we want you to do is to kind of review in your mind the things that we've talked about just now. And most of this then see if that person is named as the agent to handle it. And like Chris said, if someone else is also named as agent, co-agent, even if it says that either of them can act, the title company is likely going to require that both of them act. So it'd be good to know that the two agents are on the same sheet of music right off the bat. And then we talked about real estate power. Let me talk about, we'll mention one other thing, that funny word durable, right? That's kind of an unusual use of the word durable, but it's important in these powers of attorney, and it triggers the thought that unless it has a provision in there that says it continues, even if the principal's disabled, it's not going to work if the person's disabled. It has to be durable. Now, actually, the language in the power of attorney is going to say somewhere in there that the principal intends for this to continue to be in effect, even if they were disabled. Okay. Now, another aspect of this is it already is the power of attorney already in effect, or does it go into effect when mom becomes disabled? Many of these durable powers of attorney don't go into effect until the person becomes disabled. Well, this creates another problem for you because, and for the principal, because they're going to have to prove that mom is disabled. This means they're going to have to get letters from a couple of doctors saying she can no longer manage her personal and financial affairs. So knowing that that it is durable, it was intended to work even though the person is disabled, and that it's in effect, went into effect immediately rather than going into effect when they become disabled is important things to know about this power of attorney. And then let's see, the next line says, do the powers need to be initialed in order to be effective? Well, it just depends on the form. But in your examination of this form, just take a very obvious view. Many of these forms have a line in front of the power. And it says in the heading, it says, put your initials in front of each line that you intend to give effect to. Or it says at the end, if you initial this line, then all the powers are in effect. The reason I mention this is because we've seen powers of attorney, I guess they were do-it-yourself projects, where nothing is initial. It's signed and notarized, but none of the powers are initial. This is not a good start for these things.
That's pretty common.
Yeah. Okay, this issue of the original power of attorney, what we're driving at is that in Texas, you can't sell or transfer, you can't transfer property, real estate, with a power of attorney unless the power of attorney has been filed in the deed records, okay? So the problem is very frequently when people do powers of attorney, they are not initially filed, okay? So when you see the power of attorney, that's the reason you need the original, or somebody needs to be able to find the original, because you cannot file a copy of a power of attorney. You have to have the original to file it. Now, in some cases, you're going to, when the power of attorney, when the person presents this to you, you'll see that it's been stamped that it's filed. So in some cases, the thing's already been filed, and so you have a copy of the file. Well, that'll be okay. But in most cases, you're going to have this issue that the family's going to need to be able to find the original so that it can be filed as a preliminary to the real estate transaction. And then, Chris, you talked about what the signature looked like, and it's perfect. I mean, it's legal to sign with an X. It's legal to sign, not to have terrible signature, and yet we see signatures in our practice that would raise a question, even though they've been notarized. A financial institution or a title company is going to raise an eyebrow when they see the signature, or it's scrawled on the side of the page. It just seems like a scribble. So that's going to raise questions. And so in your coordination, you may want to see if a new one can be done, see if this is, if the title company will allow the use of this. So it could, even though it's been notarized, it could stop your transaction. All righty, so those are some things to look at. If you don't have a power of attorney and somebody's incapacitated, now what are we going to do, Chris?
Well, first thing you should do is abandon any hope that that home is going to close anytime quickly.
That's right. Abandon hope. All you enter here.
And so it's just going to be a very unfortunate situation, because what's going to happen is that to be able to transact for mom or dad, that their kids are going to have to go, or let's say it could even be one spouse for the other. Somebody's got to give legal authority to be able to act for another individual. And so what's going to happen is there's going to need to be a living probate. Now, some of you may be familiar with death probate. Well, a living probate is the process in which a guardian is appointed to handle another person's affairs. Now, a living probate, really all I need to say about it is that it's going to be a long and drawn out and expensive process for the family. And so first of all, the family is going to have to petition the court to be named guardian. And then from that point on, once they're named guardian, all major transactions are going to need to be approved by the court. And the sale of the home is definitely going to be included in that list of major transactions. And so that's another step that's going to have to be overcome before the home can be closed on. And so it's just going to be an expensive, difficult process for the family and ultimately for you trying to get that home sold. So these power of attorney documents are extremely important. Now you might think, well, that sounds like just a bunch of headache and I'm not going to deal with that. I bet I can just get away with this and have the document signed anyway. I would absolutely advise to avoid that train of thought. So the document is going to be reviewed at multiple layers between notaries, title attorneys, and just a variety of parties. They're all going to be looking at this thing. And more importantly, you just don't want to have anything to do with any sort of fraud, because that's what this could be considered as.
Also, if the person's in really bad shape, it'll show up, and the whole process is going to be pretty embarrassing. So
Yes.
just don't mess with it.
Yeah, it's just unprofessional. All right, so you're probably asking, is there a better way to avoid all of these issues? Even working with a power attorney has its own set of issues. And so there's certainly a better solution, and it's all about planning the right way. It takes some upfront effort to do so. And we'll talk a lot more about this, but with trust-based planning, the whole process can be a lot smoother for you as a real estate agent if your clients title their home in the name of a trust. But before we talk about that, let's talk about some other types of estate planning that you might see in your practice as a real estate agent. So that brings us to part 3 of the presentation, selling the home of a person who has passed away. And just a bit of professional advice is that we deal with people who have had loved ones pass away recently, basically on a daily basis. And it's a difficult part of the job, but necessary. And so some of the things that we've learned is that you really do have to be sympathetic of the strong emotions that they're going to be feeling at that time. People don't always act with, a linear train of thought. And now I'm not saying you need to be their therapist or anything, but by utilizing active listening and again, being sympathetic to what they're going through, it'll go a long way, and it'll help develop trust between you and the client, as well as understanding and overall just a better experience for everybody. So when somebody has passed away and we think of estate planning, like I said, most people think of last will and testament, because that is the most common sort of estate planning document out there. But that is only one of the many types of estate planning documents that there are. And so we're going to run through a couple of the ones that you'll likely run into, if you haven't already, in your practice as a real estate agent. Okay, so the first plan that we're going to talk about is the most common plan, which is not having a plan. It's called dying intestate. And so it is the most common estate plan that's out there, actually. So recent studies by AARP and caring.com, both done within the last few years, both showed that approximately 60% of Americans do not have any estate planning. And of that 60%, 50% of those have been meaning to, they just haven't gotten around to it. So people know it's important to them, but most people end up dying without having a estate plan put in place. But what happens is the laws of intestacy apply, and that's the state's rules for what happens to the assets if you die without a will. And basically they're trying to get it to your closest family members as possible.
There was a probate judge in Harris County that died without a will. Holy cow.
Yeah, it's amazing. And anytime that somebody dies without a will and they have assets, it will likely result in a probate. Not all the time, but it is likely.
And it's going to be a big headache for
That's right.
everybody.
A probate without a will
Is an additional headache
is
and
an
an additional cost.
It's almost twice as much as a probate with a will. So now we're talking about wills. A will is formally called the last will and testament. And really what it is it acts as a safety net. You know, you can imagine a trapeze artist. There's always a safety net underneath. And so what it does is acts to catch any assets that might be out there and distribute them and retitle them to the appropriate parties. And so a will actually guarantees a probate. A lot of people have misunderstandings about that, thinking that, well, I've got a will, it's initialed on every page, it's signed, it's notarized, perfect form. So I'm just going to take that will to the bank or to the title attorney. No, that's not the way that it works. For a will to really be powerful, first of all, it only has effect after death. And a judge has to give his approval or her approval of the will and of the executor acting as an independent administrator. And the way that the executor receives that authority to act is with what's called letters testamentary. So that's what the court will provide the executor, and the letters testamentary are what are taken to the bank, taken to the title company. And that's how assets are retitled.
And you can only get them by going through probate.
Exactly. And so the point is, if somebody has passed away and you're dealing with their children or the spouse trying to sell the home, and there is going to need to be a probate because they have a will, well, you want to get that process started early. And we'll talk more about the probate process and really the time frames, et cetera. But you just want to know that you want to start addressing these issues as quickly as possible because they do take time and could hold up your closing. All right, next is trust-based planning. And so typically and formally it's called a revocable living trust. That's a trust that you set up during your lifetime. You can revoke it, amend it. It's really business as usual for the person who sets up the trust. And it is a complete and comprehensive replacement for a will. One of the bright spots, biggest issues is that it avoids probate. There is no probate if there's a trust and if the assets are appropriately titled in the name of the trust. We'll talk more about that as we go on. And a trust is going to be much easier for you to navigate as a real estate agent selling the home of someone who's disabled or passed away. So if you help a elderly couple buy a home, well, your hope is, I'm sure, that eventually you would also help that couple sell the home, or that if one of them passes away, then you would be able to help the survivor sell that home and potentially downsize or move to a senior living facility. But a trust is going to make that process a lot easier for you because there's not a probate and there's already going to be named successors who can act and have full authority. And so you're not going to run into a lot of these other issues. Another instrument that you might see is a transfer on death deed or a ladybird deed. And so these are set up and filed in the county records. And there really are two different types. There's a transfer on death deed and a revocable general warranty deed, which is what we call the ladybird deed. But both of them act very similarly with some very specific and important differences. And so the way that it works is that the homeowner deeds a interest in the home after they pass away. But they retain the right to live in the home, and they even retain the right to sell the home if they want to. In the meantime, if they do sell it, well, that future interest is just worthless. And we do a lot of these when it comes to Medicaid planning, but they can be useful in other purposes as well. And because as soon as the homeowner passes away, then all that the son or daughter or surviving spouse has to do is file an affidavit of death with the county records, and then the home is officially theirs and they can transact on it. So it's a very quick and easy way of transitioning the property after somebody passes. But again, it's very specific. So if you've got a client who's considering something like that, you'll definitely want to speak to a firm like ours who does a lot of Lady Bird deeds. Okay, next thing we're going to talk about is an affidavit of heirship. Now, right off the bat, I'm going to say this is not a plan. Having an affidavit of heirship is not a plan. It's just a reactionary action that we take to help retitle the assets if we can. So an affidavit of heirship is something that's filed with the county records showing a transfer of ownership to the rightful intestate heirs. And it only works with real property interests, so this can't be done with a bank account. And it only works in limited circumstances. And so, some families have, husband and wife, long time marriage, 2 kids of the marriage, and both parents have passed away. Well, that's a fairly simple example, but there's other issues involved. Like, is there debt on the property, or was there debt on the estate? Does the family get along? There's lots of issues. Because if you do an affidavit of heirship, let's say in that example, there were 2 kids, parents passed away, and now they are the rightful intestate heirs. We would do an affidavit of heirship showing a transfer of ownership to the kids. But at this point, they're going to be joint tenants. And so they will have to agree on the sale of the home. And so if you have a family where we've seen it where there's 8 or 9 kids, and it's going to all of them in equal shares. The more parties you have, the more problems you're going to have, because there's more likelihood of a disagreement. It just takes one person to hold up the whole thing.
Well, even with 2 kids, we've had a situation where one wanted to live in the house and the other one, of course, wanted to sell it and divide the proceeds. Well, that transaction is not going anywhere anytime soon.
That's right. And the point is, with an affidavit of heirship, again, it's a reactionary thing that we do if we can, because it's a lot cheaper than doing a probate. And so anytime somebody passes away and they come into our office to do a probate initial, which is a free consultation that we hold to see what we can do for the family, the first thing we're going to look to do is see if we can do an affidavit of heirship, because it is cheaper and less time consuming. And we're always looking to save our clients as much money as we can by still effectively and efficiently administering the estate. And then a pretty common type of estate plan out there is a lawyer's favorite, the do-it-yourself estate plan. And they are, abundant out there in society, of people who really just thought that they could do this on their own and have clearly homemade estate planning documents. Sometimes they could just be a letter. Other times you'll notice that they are just clearly online forms that were free, that were just fill in the blank. These are just a recipe for disaster. We see these things all the time, and we simply cannot utilize these documents in certain instances if they don't have the powers that we need, if they don't have the correct language. And typically the sad part is the family doesn't know until after the fact. It's too late at that point to do anything about it. And for that reason, a lot of times we analogize estate planning to a fire extinguisher. So a fire extinguisher is unlike a lot of things that you buy, because when you buy it, you don't go home and test it out and see if it works and take it back to the store if it doesn't. No, what do? You stick it under your cupboard in your garage and just count and hope that when that thing's needed, that it's going to work the way that it needs to work. Well, the same is true with estate planning. You're not going to know until the time comes whether it's going to work the way you think it's going to work. And that's why it's very important to have quality estate planning documents and have help from an estate planning attorney who can really put a full holistic picture together of what's happening and what the documents need to say. So if you see clients, your clients who have these clearly insufficient documents, well, it's probably a good idea for your sake and for theirs that you recommend that they get quality documents put in place.
Or if it's too late for that, call us and see what kind of a problem we have
Yeah.
in hand.
Yep, we can help navigate these sorts of issues, and we do it every day. So let's talk about how the transaction is actually going to work. So we're selling the home of a person who has passed away. And so we want to throw some humor in there. And it says, did you know the word homeowner has the word meow in it? Good luck ever pronouncing it the same again. I don't know about you. I couldn't get this out of my head for at least an hour after the first time I read it.
Home meowner.
Home meowner. All right. So this is a scenario. So if you haven't seen this, likelihood is that you will eventually see this scenario. If you've been practicing for a number of years, you probably already run into this. So you're close to the closing of the home, and the title company asks for the documents related to the estate. Neither you nor the family has those documents. Well, now the closing is going to be delayed. And that's why it's extremely important. Again, you need to ask the right questions early. And so you need to ask to see the estate planning documents. And if you have questions, you need to reach out to an estate planning attorney like us to be able to make sure that the process gets initiated as quickly as possible. And so, well, there's a lot to consider here, but for most estate plans, you'll likely have to deal with a probate. And that is true, like we said, if the decedent has a will, it's almost certainly going to have a probate. If the decedent didn't have any estate planning at all, or they had some do-it-yourself estate planning that was insufficient, there's a high likelihood that a probate will be required. And so spotting these issues early on is very important, again, and reaching out and having an attorney that you feel comfortable with is going to be useful to you and saving your time and efficiency in business. And so a death probate, what is it? We talked a lot about it. Essentially, a death probate is the process in which the assets are retitled from the name of the deceased individual to the name of their rightful beneficiaries. And so the judge gives legal authority for the executor to actually sell and transfer the assets, and the court overviews the whole process. If there is a will, can be less overview. If there's no will at all, there's likely going to be more court overview throughout the process.
And also the executor is responsible for paying the debts of the decedent. So that's part of this process too, if there are debts.
Absolutely. They want to make sure everybody gets taken care of and that everything gets passed along the way that it should, including the creditors. Now, the thing about probate is it is not a quick process. You're not going to expect to get this thing done overnight. I mean, just think about any time you got to go to court. It's not quick and it's not cheap. And so, yes, so probate is expensive, and you can expect a delay of at least 2 months. And that's just to get the letters testamentary to be able to transact the property. So that's exactly why you by the family, because you're going to look at least a 2-month delay. Additionally, some issues that families really don't like about probate, beyond it being expensive and time consuming, is that it's a public record. This is a public hearing. So there's going to be an inventory of assets done. That's going to be public record. It's also going to be public record who those assets went to. So if there's any predators out there looking to take advantage of a family member, well, that's a great place to start. And so there's a lot of concern about that. Additionally, if you own properties in multiple states, or your client owns properties in multiple states, let's imagine a home here in Houston, but then a vacation home in Colorado or Florida. Well, those are other jurisdictions. And if you own real property or property in other jurisdictions, there's a likelihood that you're going to have to do a probate in that jurisdiction as well, or something similar to a probate. So again, you want to begin this process right off the bat. true cost of a probate. So in our office, a bare bones probate costs $3,500, and that's with a will. If there's no will, typically the costs start at around $7,000. So you can see how important it is to have a will. It does reduce the cost dramatically, but if we can avoid a probate, then sure, that'd be fantastic to avoid these costs altogether. A lot of lawyers out there, they love probates because they are expensive, time consuming. Okay, so what do you do if you run into this situation and you're approached by the family to sell the home of somebody who's passed away? Well, first thing you want to do, just like before, you want to be aware and ask the right questions. You don't want to rely on any assumptions that you may have about the family, about the relationships. Be very specific and ask the right questions. Again, don't wait to act because these things take time to process. And then if there's any issue at all, give us a call at the Bond & Brown Law Firm. We've been in business for 25 years and have efficient processes for dealing with all these issues. And we offer free consultations, and that's a huge help for a lot of families. It truly is a free consultation, and we need to do that to be able to see if we can even help the family or not. All right. Bob, would you mind running us
Alrighty,
through
so
some more case studies?
let's do some review on this last will and testament business. So the seller has mom's will. The document looks very official. It's initial on every page. It's signed, witnessed, and notarized. The seller is designated as the executor. The seller says to you, I don't see why I need to go to court. It's perfectly clear that I can sell the home. So this is actually a very widespread notion. It's really based on wishful thinking, I think. But anyway, people get a will. They did the will years ago. They kind of forgotten, what was said at that time, and they pull this out, and it is a very official looking document, and it clearly says who the executor is. And so the surviving spouse, who's not in a particularly good mood to begin with, just when you say probate, and she or he's thinking, what are you talking about? This thing is clear as a bell. Why would I need to go to court? And so, so the issue for you is that if you're trying, if we're in the process of trying to get this on the market and getting it sold quickly, you don't want that person to continue in that vein for very long. And she may not take seriously what you tell her. I mean, she just needs to hear it from a number of angles. So this is a great opportunity to say to her, well, I'm not an expert in this. Why don't you talk to these people? We work with them, and give us a call, or ask her to give us a call, because what you want to happen is she needs to realize that she's going to do a probate if that's what's going to be needed. And she needs to start it ASAP. That 2 months we're talking about doesn't start until the executor sits down in our law firm and says, yes, go ahead with it. And then we have to do the application for probate and submit that to the court and begin all this process in order to get the hearing finally set and get the judge to approve the probate and issue those letters testamentary, so you can actually do the closing, hopefully in 60 days or so, when the executor has authority. So you need to get them out of the mood where they don't think they have to do anything, and get them to us so we can figure out the best thing for them. Okay, you receive a call from a prospective seller wanting to sell her recently deceased mother's home. When you meet, she shows you a deed with both mom and dad listed as the grantees. She tells you dad died years ago and they thought mom automatically owned it. Is she right? Okay, this is another enduring mistake or misunderstanding that people have. Most married couples have joint accounts with right of survivorship at the bank. That's the way their joint checking accounts set up. And they may have other assets that are set up in joint tenancy with right of survivorship. And they have come to believe that if both the husband and wife's name is on an account, on a title, that if one of them dies, it will automatically belong to the survivor. That is not true of Texas real estate deeds. There are very few deeds in Texas that are in joint tenancy with right of survivorship. And often when they are in joint tenancy with right of survivorship, this raises other questions. That's part of the reason they're so rare in Texas. So if dad died years ago, there has to be an action to clear the title. The question that the title company has is, where did dad's interest go? Because it did not automatically go to mom. It could have gone to dad's children from a prior marriage. Something's going to have to be done in order to clear title from dad to mom. Now, in many cases, we can use an affidavit of heirship, but in some cases we can't. We'll find the best solution. But the point is, they've got two problems here. They got the problem that dad died, and we've got to deal with where his interest went. And then we've got mom has passed away, and we've got to deal with who has control of her interests now. And of course, our goal is to get them to whoever just talked to you, if hopefully that all works together. So if deed's in both names, we're either going to have a probate or we're going to have to do an affidavit of heirship. Do you know how transfer on death deeds work? So let's talk about that for a second. She tells you that her mom died and asks you to look at the deed that gives mom's home to her. And so she pulls out a transfer on death deed or a ladybird deed, and it shows that she's the grantee. Now, at some point before this closing takes place, an affidavit of death, or it could go by other names, but essentially an affidavit of death needs to be filed in the deed records to show that the grantor has died, and now it belongs to the grantee. So that's part of getting your person ready to be able to sign at the closing and get everything set up with the title attorney. So there needs to be an affidavit of death done. But the other issue that these ladybird deeds or transfer on death deeds may create is if there's more than one child. Let's say that the deed goes to one kid, but mom and dad had 2 or 3 kids. The title company may demand, as part of the closing, that the other kids quit claim their interest to the child that's listed as the grantee. So, or some such action. So the point being is, if there are multiple kids, but only one of them got the deed, the property, then the title company's they're not going to be confident that there's not a problem there. And so they're going to want the other kids to bless this transaction. So you're probably going to have to see if everybody's is aboard for this transfer to the one kid. So if there are questions about that, or questions about what needs to be done, it's another good chance to give us a call and make sure we can keep this going in the right direction for you. Tax issues. Let's talk about tax issues for just a second, because they'll come up sooner or later many times when you're dealing with any kind of sale of real estate. So just to review, in this particular case, versus the sale of real estate, is there a difference? So if a disabled person sells their home, they're going to get the step up, the exemption from capital gain, the $250,000 for a single person, $500,000 for a married couple, the exemption from capital gain. So there's not going to be any capital gain in most cases on the sale of a disabled person's home. But if that disabled person was selling a rental home, or selling a lot, or selling agricultural property, now there could be a big capital gain involved if the sale takes place before mom or dad passes away. And so this brings up the other part of this that's good to keep in your mind, and that is, in many cases, it's better from an estate planning standpoint, to pass away owning the property rather than giving it away before you pass away. And so, there are not many advantages of dying, but this happens to be one of them, that when someone passes away, all their property steps up in basis, they call it. And what they mean is it erases any unrealized capital gain. So you can easily imagine if somebody owned a lot or a piece of ranch property or a rental home that they'd owned for years and years, and it had appreciated substantially. Well, if they sell it, if that disabled person or the family sells it while the disabled person is alive, there's going to be a huge capital gain. If that person passes away, no capital gain. So big difference there. And so that's also that second line. It says gift of home by elderly person to children, possible disadvantage. Well, that's the same idea, that if the elderly person gifts home or their home or any other real estate property to their kids, the kids get the same basis mom or dad had. So if they bought this property years ago, or this is a neighborhood that's gentrified and the price is shot up, if it's gifted to the kids and the kids ever sell it, they get mom's old basis back when she bought it years and years ago for a pittance, right? And so they're going to have a huge capital gain. On the other hand, if mom died with the property, no capital gain. So big difference there in certain cases that you want to be aware of. So I think we covered that on the tax issues. All righty. Chris, tell us a simple solution to all these problems.
All right. So this is part 4 of the presentation, our final portion of the presentation. And so the simple solution to these problems is going to be the use of trust-based planning. And so a lot of people have misconceptions about trusts, that they are for the super rich, or that they're extremely complicated, and it's just not true. But as long as you understand a couple of basic elements of what trust planning is, it's easy to wrap your head around. And so the easiest way to think about a trust is to think of it as this treasure chest that you see on the screen here. And so that treasure chest, the trust, is going to hold all of the assets. And it's also going to have instructions for key provisions, like who's going to manage the assets, where do the assets go, and it can provide lots of rewards and restrictions. Additionally, it has built-in protections that we'll discuss as well. All right, so a treasure chest is great, right? But it's still just a box until you put treasure in there. And that's what we call the funding process. And so by funding the trust, what we mean is that we retitle the assets. So we deed the home to the name of the trust. We retitle the bank accounts to the trust so that everything is owned by the trust. And that's typically the part of trust-based planning where, let's say if you downloaded a form online, they're not going to help you fund the trust appropriately. That's something that we take pride in, because that's where most mistakes are made when it comes to trust-based planning, is actually getting the assets into the trust, because the trust only has power over assets that it owns. And so if you don't fund appropriately or don't fund anything, then the trust won't have any power at all. And that's how we avoid probate. And so just some basic things about trust-based planning. There's 3 positions to any trust. There's your trustor, that's the person who created the trust and put their assets in it. There's the trustee, that's essentially the person with the checkbook. It's who manages the trust. And then there's the beneficiary, who of course benefits from the trust. Now the good thing for your clients is going to be that if they set up a revocable living trust, then it's still business as usual for them while they're alive and healthy.
10 o'clock on Thursday work for you?
And so all of your client will occupy all 3 of those positions, and can still use and sell, transact their assets as they would normally. They can also still amend and revoke the trust during their lifetime. But after one of them becomes, or after one of the spouses passes away, or one of the trustors passes away,
We don't take
then
a
a portion of the trust becomes
Tuesday?
irrevocable.
Tuesday the 19th.
Sounds like we got somebody.
What about 10 o'clock on Tuesday the 19th?
Sounds like.
Okay, I'm gonna put you.
And the clients can buy, sell, refinance. The point is they get to treat the property just as if they would. However, the big advantage is that now there is a detailed listing of how the property can be sold. And so let's say mom passes away. Well, now there's a named successor trustee who can basically immediately step in and manage the affairs right away. And so this is, again, why we recommend that if you help an elderly couple purchase a home, that they set up a revocable living trust and title the home in the name of the trust. Because for you as a real estate agent, when it comes time to sell that home, well, you're going to know that there's not going to be a big holdup, because the successor trustee can already sell the home if the client is incapacitated or if the client has passed away. And there's no need to get the court system involved. So it's going to be a huge benefit to you as an agent, but it's going to be really a huge benefit to the family, and they will appreciate the advice. So what has to happen if there was trust-based planning? Well, if there was a trust, it's a simple process. It's that the successor trustee will be appointed if they haven't already, and they'll provide a signed copy of the trust to the title company, not even the whole trust, just a document called an affidavit of trust or a certificate of trust, detailing some of the key provisions of the trust.
Relating to real estate transactions.
Relating to real estate transactions. And the successor trustee can then sign the deed and transfer ownership of the home. It's much smoother, as you can tell. We're not talking of any 2-month delay or anything like that. And so it's a much smoother process.
Potentially, a trustee has control of a decedent's estate as soon as they get a death certificate.
Mm-hmm.
So
yeah,
that's probably going to be in 10 days or 2 weeks in the typical case, rather than us having to go through the probate process, get it initiated, and wait 8 weeks.
And that is typically the biggest holdup, especially right now with the COVID-19 issues, is that death certificates are taking longer to get out to families. But really, that's all you have to wait on, is receiving that death certificate.
And the probate court wasn't even scheduling hearings.
Yeah.
So.
All right, some other benefits of the court system not being involved. So a trust is considered disability and death planning. So it does address what happens if a trustor becomes incapacitated, what happens if both trustors become incapacitated. It handles every scenario that you can think of. And so, like we stated earlier, there's no need for a death probate. So there's a lot more work involved with trust-based planning on the front end. And the reason for that is, well, we're retitling the assets, right, into the name of the trust. And, you know, it's a good time to do that now because the trustor is alive and healthy and well and able to navigate all these things. Well, probate has the same process. It is retitling the assets. But at that point in time, the person who owned the assets is no longer available to if you don't have trust-based planning, there's going to be a lot more work on the back end, and that's your probate. And again, it saves the family $3,500 by avoiding a probate with a will, or up to $7,000 for a probate without a will. And so basically it's like I said at the very get-go, a trust is a complete and comprehensive replacement for will-based planning. And it can save the family a lot of time and money, not on the front end, but on the back end. All right, let's run through a little pop quiz. You want to do that, Bob?
Sounds good.
All right. So
Let's see, what are the 3 positions of a trust? The every trust, they always talk about this, and it sounds confusing, but it's not. It's the creator of the trustor, and then who's got the checkbook, who decides how the property's handled, and who decides about the distribution of the beneficiaries. It's the trustee. And then the beneficiary receives the benefits from the trust. If a client has a trust, can the trust be changed while the client is still living? The revocable living trust we're talking about is exactly that. It's revocable and amendable as long as the client, or if it's a husband and wife, depending on its structure, as long as either are alive. Once one or both of the spouses passes away, then the trust is irrevocable at that point. It says, can anyone change the terms of the client's trust after he or she is deceased? Technically, it's irrevocable at that point. There are some angles on this, but the short answer is once the person passes away, then what they have created, what they have directed is fixed at that point. When a client with a trust dies, why is a probate unnecessary? This really throws people because the will seems like such a formal document, and yet it's got to go be approved by a judge. And then you have this trust, it's a formal document, but how come it doesn't have to be approved by anybody? Does it have to be filed? What's the deal with this? No, the reason the trust has power is because, as Chris said, the account is in the name of the trust, or the real estate is titled in the name of the trust. That's what gives the trust its power. That's why the trust doesn't have to be go to court. It doesn't have to be filed. Once it's in the name of the trust, then the trust becomes the reference document for the financial institution or the title company. How soon after a client dies can his or her successor trustee sell the client's home? And the short answer to that question would be when it would be possible is once he has a death certificate, probably about 2 weeks. It's unlikely it would actually transpire that quickly, but the point is this is quicker, easier than the probate process. Any other benefits to a trust? There are many other benefits to a trust, and Chris is going to talk about some of them.
Thanks, Bob. Yeah. And so let's talk about some of those extra benefits because they are numerous. And like I said, there's a lot of misconception that trust-based planning is for the super wealthy. Well, that's not necessarily true because it's also extremely important based upon personal circumstances, because trust-based planning can provide many benefits that are important to certain individuals. And so first of all, there's a big fear that with many families, with good reason, that once one spouse passes away, that the surviving spouse is going to get remarried or cohabitate or maybe even just fall victim to a caretaker. And so many people do get remarried after the spouse passes away, even when they don't think it's going to be the case. And so we can provide protections through the trust-based planning that really sets in stone the direction of the first spouse to pass away so that the kids do benefit from that half of the assets. And so a remarriage can send an estate plan completely sideways real quick. So there's ways that we can address those concerns with trust-based planning and make sure that the assets do go where they're intended to go. Think about it this way. If you used will-based planning and left everything to the surviving spouse, and then that surviving spouse gets remarried, and then their new spouse survives them, well, everything's going to end up going likely to that new spouse's children, and your kids get left with nothing. So it's a serious concern, and it does happen. Another major concern is divorce protection. So a lot of marriages in America now end up in divorce. And so there's a fear that if you leave your inheritance to your children, if they were to get divorced, that the divorcing spouse might walk away with up to half of the money that you left for your child. So there's ways of protecting that, because if your children inherit money in a irrevocable trust instead of just giving it to them outright, there could be broad discretion provided to your son or daughter so that they can not feel constrained necessarily, but what's going to happen is the assets in their trust are never going to pick up community property characteristics. Not even the capital gains on those assets are ever going to pick up community property characteristics as long as they remain in the trust. And so that's a huge protection, protecting your children against losing out on if they get divorced. Also, if you got minor children simply can't inherit property. It has to be held in trust until they reach an age of majority. And a trust can be used for all sorts of purposes, either special needs or, but more specifically, taking care of minor children over the course of their childhood and potentially even up to, in their mid-20s. So it can get paid out over time. There's a common saying in estate planning, it's divide, dump, and dissipate. Well, that's not what we want to see happen. We don't want it to dissipate. We just want to keep the estate going as long as possible so that your kids are going to benefit far out into the future, maybe your grandkids, maybe even your great-grandkids. It really depends on what your goals are. Another reason why trusts are used is for if there's special needs children or special needs beneficiaries who are receiving government benefits like Medicaid or SSI, then an inheritance given to them can actually kick them off those programs and do more harm than good. And so with what's called a special needs trust, we can provide supplemental income while keeping the beneficiary on those medical programs. And then lastly, so we've talked a lot about how these issues affect your clients and your relationship with your clients as a real estate agent, but we also do want to encourage you to think about your own personal circumstances. So this is a painter's house is never painted. So I hope that when we've been speaking about all these issues that you've been thinking also about how they relate to you. And if you have any questions or concerns about your own estate planning, that you give us a call and set up a free consultation. They really are free consultations. And so what do you want to do if you are hiring an attorney or if you're looking for an attorney for your clients? First thing you want to do, make sure that they specialize in estate planning. There's a lot of attorneys out there that will do an estate planning document that do not specialize and really have very little knowledge about the details and impact of what they're doing. We do specialize exclusively in estate planning and Medicaid qualification. If they do specialize in estate planning, then you should look to see if they're members of the American Academy of Estate Planning Attorneys. That's an organization of small estate planning firms across America. It's about 150 members, and it's an just incredible organization because it allows us to keep up with best practices. It's also the organization that created the software that we use our documents off of. So we are proud to say that we have the best documents out there. I mean, they are really top notch. And additionally, you want to make sure that free education is offered. Obviously, we offer lots of free education. And then here's a really important one. So are they in it for the long haul, and are they relationship based, or are they document peddlers? For us, relationships are what's most important. And this is a business of relationships. We want to make sure that whatever we put in place for you is going to work for you and your family members. So if something happened to you, we hope that your children come see us. If something happened to them, we hope your grandchildren come see us. We are this plan works for your family throughout time.
And your clients, if you're referring to us.
Yep, absolutely. We take a lot of pride in the fact that families trust us to set up their planning and take that very seriously and really do care about our clients. And then lastly, upfront and honest pricing. So the way that we do it is a free initial consultation, and then we'll figure out what work needs to be done and then quote a price for it. We've been doing this for a long time. We know what the work entails. And so we don't typically charge by the hour and have surprise billing like some firms. So a little bit of diligence will go a long way. Now, I hope that you've enjoyed our presentation today, and if you have clients or are hosting any small private events and need a speaker, then we would be very happy to present for you either this presentation or one of the other many presentations that we have, such as we have lots of presentations for pretty much any sort of estate planning need. And so we would love to present for your group, and just give us a call or send us an email and we can try to accommodate that as soon as possible.
Chris, there was a question, and I'm not sure if you saw this, but somebody asked, is an executor and an administrator one and the same?
So an administrator is appointed by the court where there is no will. So a will typically is going to appoint an executor, whereas if there's no will and no executor appointed, then the court will name an administrator. And so that's the difference. You have an executor where you have a will that appoints one, and if there's no will, then the judge is going to appoint an administrator. So, but it's still the probate process.
Yep, and the administrator is going to have to check in with the court a lot more often than an independent executor would.
Correct.
But real quick, what I want to do is bring this all together for everybody. And so I know that some of you online would be looking for your CE credits. And so what we request is that you should have received an email. If not, you'll receive one shortly. But if you could reply to that with your name, your real estate license number, your email address, phone number, and your address, we will record you into the system. And there is a $5 fee for the CE credits. That's not for us. That's just a requirement for the CE. And so you'll get the 2 hours of CE credit. But additionally, we do absolutely recommend that, if anything that we've talked about today seems important to you personally, not just to your clients, then we encourage you to give us a call. So our consultation, I can't say it enough, is free. And they do fill up quickly though. So we encourage you to give us a call and get something on the books. Even if you don't think you can get your appointment scheduled right now, get something scheduled for the future. We're doing appointments over the phone, through Zoom, and also here in office. For our in-office appointments, we're making sure to stagger them and be respectful of social distancing. So please give us a call. Now, if you do give us a call and set up an appointment, I talked about estate planning as being kind of like a fire extinguisher. Maybe a parachute's another example. It's not something that you're necessarily looking for a bargain on because you want quality. But we do still realize that people are looking for a bargain. And so in appreciation of you watching today, we are willing to extend a $250 educational credit for all new trusts done, or 5% off of any other planning. Now this is not necessarily for your clients, but anybody who is a participant on this presentation today. And so just give us a call and we'll be able to set up an appointment and you can utilize that educational certificate. Now, to be able to utilize the certificate, we do ask that you schedule your appointment within the next 2 weeks. That way the stuff is all fresh on your brain. If you are married, then we request that both spouses do attend. Again, it can be on Zoom or here in person. And we do realize sometimes one spouse handles more of these issues than the other, but we found it to be extremely important that both spouses be there. And then lastly, we ask that in the end of the consultation, so at the beginning of the consultation, we'll ask questions, get a firm understanding of the situation, then you'll have the opportunity, or your clients will have the opportunity to ask questions. And then we'll build a plan together, and at the very end ask, are you ready to proceed with us today? And really all we ask for is a clear yes or no answer. That does not include maybe. That's really important for us. It helps establish the relationship. And it's important for you also because you're going to know if this is something that's still on your to-do list or not. And so if it is a no, that's perfectly fine with us. I said it before, this is a business of relationships. We will be better off for having spent the time together, and you will be better off for having learned more about estate planning. And so we really do encourage you to give us a call and schedule something for yourself and your clients. And I really did talk about what to expect right there. So yeah, let's go ahead and move on. Are there any additional questions?
There were a few questions in here. One from Adrian.
let's,
A revocable trust become invalid.
Let's stop the share and
Was
we'll be able to
mentally
see it.
disabled.
Okay, one moment, please. There we go.
Oh, can you see the question?